so much. Okay, welcome everyone. It's 1:02. We're coming out of recess from our morning session for the purpose of hearing several land use items. The first two are rezone hearings. The third is just to set a date for a future hearing, and then we'll be holding a hearing on some minor regulation updates. But for the hearings, they all follow the same general format. The staff will present the application to us with a recommendation. We may or may not have questions for staff at that time. We will then invite the applicant to provide any additional information they may want us to consider. Again, may have questions at that time. Once that portion's closed, we'll open for public comment. And then once public comment is complete, we'll invite applicant and staff as appropriate to respond to any issues that may have been brought up. We may have additional questions based on public comment as well. And then at that point, if we feel we have enough information to make a decision, that decision may be to approve, deny, or approve with conditions. If we don't feel there's enough information or there's something lacking, any of the hearings could potentially be continued until that information is brought forward. But that's generally how each of these will go. So the first we have is known as the Gerald rezone. I would accept a motion to open public hearing.
Mr. Chairman, I move that we open the hearing on Gerald rezone RZ 239401.
Second.
We have a motion and a second to open public hearing. All in favor, please say aye.
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 Okay, we're in public hearing, and I guess I missed appropriately beforehand. If you could call the roll just so we know who's here to hear this.
Commissioner Thayer.
Here.
Commissioner Richardson.
Here.
Commissioner Schroeder.
Here.
Here. Okay, so we have a quorum. So thank you. So with that, I would turn this over to Mark Deatonreiter to present for the application.
Thank you, Mr. Chair. Commissioners, I'm Mark Deatonreiter, Director of Community and Economic Development. As you mentioned, we are here to hear the Gerald rezone case RZ 23-9401. Some details of this: it's a rezone from 13.5 acres from agricultural A to residential agricultural RA. The address is 9400 County Road 7482, Peyton, Colorado. And the applicant is Levi Gerald, and the owner is Jeremy and Kim Carell. The process for this particular case began back in 2022 with a pre-application meeting. A community meeting was held later that year in October. Formal application the following year in August. Planning Commission heard this on June 18 of this year, 2024. The Planning Commission actually heard it before that on May 7th, but there was a noticing item that was raised, and it was determined that there was an issue, and it was in fact remedied by the applicant, and re-noticing did take place, and that's why it did come back to the Planning Commission on the 18th. The Planning Commissioners passed in terms of recommending approval of a vote of 7-0. And then here we are today on June 26 for you, the Board of County Commissioners, to hear this case. Here's the location map. It's 9400 County Road 7482, as was mentioned. It's on the Elbert, El Paso County border. It's approximately 9.7 miles from the community of Peyton, and that's in El Paso County, and then about 8.1 miles from the community of Elbert in our county. Here's the zoning map. It's currently zoned agricultural A in green, and as you can see, most of the land surrounding is also zoned agricultural A or RA or RA1. So the proposed rezoning does fit with the surrounding area. Also, as a note, to the south of this property, so you can see in this map, it's outlined in red to the south. That's the El Paso County border. And the aerial map just gives you a different view from above, and you can see some of the topography there. And to the north of the subject property, you can see County Road 7482. As part of all applications, we have a referral process. The rezone application was sent out for 2 referral periods. The first referral period took place back in August of 2023, and the second one took place in February of this year. Next slide here, we're showing you here the referral responses from the various agencies, and the applicant has acknowledged and resolved all comments raised during the referral process. Here's a rezone exhibit, also included in your packet. And we move on to our regulations. Elbert County zoning regulations, specifically Article 3C4, lists criteria A through F for any and all rezone requests. The 6 criteria we'll go through now. The first one is whether the proposed rezoning conforms to and is generally consistent with the goals and policies of the Elbert County Comprehensive Plan. This proposed rezoning conforms to and is generally consistent with those goals of the comp plan. Staff does find that the rezone aligns well with the general environment policies, which strive to, quote, safely foster a balance between the natural and developed environment while supporting private property rights. The Gerald rezone is again a simple split of a property into 2, and will keep the agricultural, rural character of the land and area. And then B, whether the proposed rezoning is compatible with the surrounding land uses. The 13.85 acre parcel is being split off from an original parcel of 54.46 acres to accommodate a new residence. In addition, much of the area around the Gerald property is zoned similarly, as we've discussed, and has a rural character, which the Gerald property will conform to as well. So we believe as staff that the rezoning of the 13.85 acres is compatible with the area and does fit with similar zoning around the property. Moving along to review criteria C, whether the proposed rezoning would adversely impact the provision of public services. And Elbert County Planning and Elbert County Public Works have evaluated the rezone application and found that it will have no adverse impact on the provision of public services. D, whether the proposed rezoning would adversely impact the environment. The rezoning will not adversely impact the environment. There are no expected adverse impacts with water. For example, parties have taken the appropriate measures to ensure water for the properties, and no environmental concerns are raised. We go to E now, whether the proposed rezoning would create unreasonable traffic congestion or burden the existing road system without improvements. Elbert County Public Works, again, has reviewed and has no objections to the rezoning. The rezone will create just the one agricultural residential plat, which will have minimal, if any, impact on County Road 74-82, and will not create unreasonable traffic or burden the county road system. And F, whether the proposed rezoning will not otherwise be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. We believe the proposed rezoning will not be detrimental, and the development does conform well with the properties around it, and which are larger agricultural properties with residences. And we move to findings. Staff does recommend that the Board of County Commissioners approve with conditions Gerald rezone case number RZ 23-9401. And we have some conditions of approval here. 4, I'll just read through them briefly, or quickly rather. The applicant will be required to remove the public hearing sign with 7 days of a decision by the Board of County Commissioners. Number 2, the rezone shall not become effective until all fees are paid, conditions of approval are met, and the rezone is recorded. And number 3, recordation of all appropriate documentation to occur within 180 days of Board of County Commissioners approval, And the last one, number 4, subject to any valid easement or right-of-way. That concludes the presentation. If you have any questions, we're happy to answer them for you. Thank you.
Do you have any questions for staff at this time? I do have one, just if you could, the final condition on the subject to easement or access. Obviously, that's not a standard one. Could you just describe what the issue that was being addressed there is?
Yes, so there has been an issue that has been raised between a neighbor and the applicant related to easements. We've discussed this with county legal, and the county is this issue is not the county's to resolve nor advise on. We are not a party to determine basically who is correct, who's incorrect, and what is a valid easement or right-of-way, that type of thing. This is something that the parties will need to resolve as a civil issue in court or through mediation, some type of an agreement if they have not already done so. So essentially making this a condition of approval subject to any valid easement or right-of-way, it essentially, future proofs, if you will, a project like this if there is in fact a decision made that there is a valid easement.
Thank you.
But I'm still trying to figure out, how do you know?
Pardon me?
If the easement is valid?
Yeah.
Where I'm going with that is this rezone, if we approve it, not valid until you receive some kind of verification?
No, not at all. This is just, it just states, again, it essentially puts this application in a situation where if there's a valid easement, then that's, it's good. If it's not, then, it's still not for the county to decide. So we are not making a decision, or you are not, on what a valid easement is. It's a civil issue. So a court, with competent jurisdiction can make that decision. So it really has nothing to do with this rezone. It's just putting this, condition of approval in there. It just sets it up in a situation to where if it's a valid easement, then, or right of way, then that's, that's good. If it's not, then that's up to the, to the parties at hand to handle.
Okay, maybe.
And we took this under advisement from county legal.
Okay. I guess let's be able to revisit that subject here at the end after we hear more.
Yep. Thanks, Mark.
Thank you.
And just so we're clear here, what we are considering is the rezone, not subdivision plat, or that would be another step that issues would be addressed prior to anybody even getting to the point of having the authority to pull building permits or other pieces. Okay. So with that, I would invite the applicant to come forward. Any information that you may have that you'd like to be considered.
Hello, my name is Levi Gerald. I'm the applicant. It's my wife, Amber Gerald, and Jeremy Correll, my in-law. He's the owner of the property. I don't have a whole lot to add, but because your guys' easement's concerns, I'll just address that right off the bat. We went to mediation for the easement. I don't have the date on me. It was about a month ago, and we mediated the easement. So the easement's valid. It's on all the paperwork. It's on all the plots. So that's the way that we're treating this as far as what we're going. So it's on all the application, and it has been. And then as far as the time frame of why this took 2 years is mainly based on waiting on water. So we got the water allocated for the property via the state water board, and that just took a long time. So that's why there was kind of a big pause there in the middle.
I appreciate that. Do you have any questions for applicant?
All of the other conditions of approval, including, if I understand what you just said, that this easement problem has been resolved.
As far as whether the easement's valid or not, yes, sir, we went to mediation and they've been granted the easement.
And the mediation is granted it?
Yeah, yes, sir.
Or stated it exists?
Yes, sir, yep. And it should be located on your guys' rezone plat as well.
Anything? Okay. No, thank you, sir. At this point, I'd open for public comment on this item. And if you would, state your name and address for the record. And then
Karin Hopper, 9500 County Road 7482. As the grantee of a 60-foot wide easement across subject property, I object to this rezone as submitted. My easement was omitted from the application process. Applicant omitted the easement from all applications, the plat map, and the cover letter questions. The easement was added to the plat map in April 2024 only after I notified the surveyor of the omission. All waivers and permits were issued without consideration of my valid easement that has been valid since November 5th, 2012. The exhibit now depicts our easement, but fails to identify applicant's proposed access. Applicant has failed to meet the ordinance requirements by identifying a valid legal access on the exhibit to the application. Applicant has also failed to depict the internal traffic circulation on the exhibit. Depiction of the easement is not the same as depiction of proposed access. This application is not complete for review or decision by the board. The applicant failed to submit a driveway permit application. Consequently, a driveway permit without the information necessary for issuance of a driveway permit. In his email waiving the traffic study, Mike Evans stated that easement road is good for 1 or 2 residences. As easement holders, we can have 3 separate parcels on our 108 acres. Approving the application for rezone with no access depicted will result in the applicant claiming that the BOCC authorized his use of the easement as his driveway. Such claims and uses overburden our easement and impact our property rights. A BOCC decision requiring us to share the easement as access for the new uses is improper. The applicant has modified the easement road in violation of the easement, ruining the crown and creating drainage and erosion issues. Also, the applicant's building drains directly onto our easement road, causing further erosion. The drainage inspection was waived by the county. More environmental concerns are detailed by Attorney Deborah Fortenberry in her May 16th letter to the county commissioners. You should have that in there. A complete application package will show an obvious solution for applicants' access. There is an existing double gate entryway and driveway from County Road 7482 on the west side of the proposed subdivision. This is the current access point for the parent parcel and should be identified as the access point for the rezoning application. I may withdraw my objection to approval if the existing driveway to the west of my easement is identified as a legal access point. And this is not an easement dispute. This is a matter of property rights. Approval of this incomplete rezone application may be a taking of my property rights in violation of the Colorado Constitution. I object to this rezone, and per Elbert County ordinance requirements, this application must be resubmitted. Thank you. Do you have any questions for me?
if we do, we'll ask after.
Okay, thanks.
After close of public comment. Do we have any other public comment on this? We'll ask, yeah.
So Jeremy Correll, I'm the landowner, and so the main reason I wanted to talk to you is why we're rezoning. So our daughter Amber and Levi are from Elbert County. They graduated right here from Kiowa High School. Upon graduation, Levi entered the Army, where he served his country for the past 15 years, and if you've ever been a parent of somebody who's serving, you don't get to see him a lot. So He got orders back here about 2 years ago. Unfortunately, since then, due to a back injury he sustained in the Army, he's been medically retired. They're home again. They're home, and they're home in Elbert County, and we want them to be next to us, you know, it's a blessing now to be with them and get to see our grandkids grow up. We missed the early part of it, but that's what, this isn't a money grab. This isn't breaking this up into subdivided lots. This is because we want family to be next to us, and they want to own their own piece of property. So I just wanted to let you know why we're rezoning this property. Thank you.
Thank you.
Do you have any comments about the right-of-way?
So that is correct, and it is mediated. It is a valid easement. I think probably, and I can't speak for the county as to why it was saying it was still disputed, was probably because at some point it was. In fact, there was a lawsuit over it. That has since been mediated. There is a valid easement on the eastern edge of this property. So it doesn't change the easement. This rezoning doesn't change the easement. The easement's there, it's valid. So it's a valid easement on the edge of 54 acres, or it's a valid easement on the edge of 13 acres. The easement's valid. Access for a property in El Paso County. So we're on the county border.
Oh, I see.
There is a property in El Paso County that's landlocked. There is an easement on the eastern edge of our property. A year ago, it was brought up by the assessor's office that it was not valid, in their opinion, which led to a dispute, which led to a lawsuit that has since been handled. It's been mediated. We've agreed there's a valid easement. And so at this point, there's a valid easement on the edge of a 54-acre piece, or there's a valid easement on the edge of a 13-acre piece. Either way, it's a valid easement.
Thank you. Any other public comment at this time? Okay. Seeing none, I'd close public comment, and if you'd like to respond to that, yes.
So to address the access concerns, all of our access was permitted through the county when we built our house last year. So her saying that our access permit was never included, I don't know where she gets that information from. When we built our house, we went through the building permit process, which included a driveway access permit, which was done by Mike Evans and granted. I haven't changed the grade of the easement driveway at all. Matter of fact, it's my primary driveway to my house. I would have no reason to do so because I have to drive on that every day to get to and from my house. So I would have no reason to do that. Also, just for clarification, the easement says in it, you guys have a copy of that paperwork. The easement says in it that the grantors, that's us, have full use of the easement area and that we can use the easement for our access to our property. And that's what we were doing. I understand that Ms. Hopper doesn't like that. That's what the easement says, and that's the terms of the easement, and we're in compliance with those terms. The other access is for my in-laws' property. It's for their house. And when the subdivision goes through, that we have to have separate accesses. So that's what those are for. Again, both of those are approved and permitted through the building department and road and bridge.
Appreciate it. Have any questions for staff?
I just have a question then about this number 4, condition of approval. If it's valid and it's on all the documents and we have it documented, is it necessary to have this as a condition of approval?
Thank you, Mr. Commissioner. Mark Denreader again. This was suggested by county legal to include this condition of approval, so we added it.
Okay, I guess my question then is if it's just the way that it's worded, that it's subject to any valid easement. So if in the future, obviously these two parties are not getting along, if there's additional litigation and suddenly this shows as a not valid easement, what happens to our property?
Yeah, again, the way it was described to me was, it gives it future-proofs it, if you will, essentially, this project, this application, if there is in fact a decision made that there is a valid easement, but from what we're hearing now from the applicant, that there is. So, given that, it may be that this condition of approval could be removed upon, further examination.
Okay, thank you.
Thank you.
I guess I'll just keep adding here. If it's really not our job to determine if there's a right-of-way there, I don't know how it makes sense for us to have a condition of approval if it's not part of what our authority and responsibility is.
Yeah, that's a good point, Mr. Commissioner. As you mentioned, and as what I've learned is, yeah, these easements are not county issues to resolve or enforce and so forth. So,
And if this access already is being utilized, you can't take it away, can you?
I need you to go to the podium, please.
Okay, please look at number 5, Article 5 in the easement. They do have access. They can use that, but they have to use it the same way that we use it. And we use it to access our driveway from County Road 7482. And they need to do the same. The driveway permit is not valid. The driveway permit was issued when our easement was not even in the application. So they cannot, they put a gate up, they stop everybody who comes to see us. If somebody's out on the easement coming to our property, they come out and stop them. That's a 60-foot wide easement. That's a road. That's for the future development of my property, which is 108 acres. So if we have 3 different families living back there, that's a road. We can put a 40-foot road in there. That's for a road. It's not for a driveway. So he can use that to access his driveway, but he should not be having a driveway permit over the easement area, if that makes sense. Also, the current Corral access, the big, huge driveway, is on their 13 acres. It's not on the parent property, it's on their subdivided property. And you see in the letter, you see there are plat maps with that driveway on it, but they've been taken off here. There's no access shown. And that's just our objection. I am happy to have them have the 13 acres. I would love my grandkids to come live by us. That's not the problem. The problem is the access and preserving the easement for what it was for, which was my property in the behind theirs. That's all. It's the easement that's important here to me, not the subdividing. The entire process, all the waivers, all the permits were done without the easement in the application. The whole thing.
Let me make sure I understand what you were saying. So the applicant can use the easement in the same manner that you do to access a driveway.
Yes,
So if they have a driveway coming off of the easement,
yes.
that is,
That's great. They just cannot use the easement as their driveway. They cannot, he says, we have a driveway permit, and this is our driveway. But no, that's not his driveway. That's an easement to get to his driveway. That's an important distinction. Because otherwise, he controls the driveway, and that we are dominant estate on that easement. For that 60 feet wide, we are dominant estate.
and the mediation that you went through did not resolve this?
The mediation was for, is the easement valid? Yes, it has been valid since November 5th, 2012. That's what the mediation was.
And so the future copies of the letters we got from attorneys was after the mediation took place?
The 12th of April. This is all new.
And that's over the usage of it?
Yes. Because all the permits were given without the easement.
And you don't object to him tying his driveway into the easement?
I do not, because those are the conditions of the easement. And that's all I'm after, is just preserve the integrity of this easement. So yes, he can have a driveway off of there, although I don't know why he would want to, since he has a much huger driveway that's on his plat, on his new property that exists already. But yet he can use it if he wants to have a driveway off of the easement area, sure. That's the rule.
So I'm still confused at your objection. The easement exists.
Easement exists.
And he already has a driveway somewhere, and
He calls the easement his driveway. And so he's gating it, he's controlling it, he's stopping people that come to see me on it. And we have, if you read the easement, we have dominant estate. We can put landscaping in, they cannot. Their
so what
rights
you're
are
saying
lower.
is, he can, by making the assumption he does, he can cause you some inconvenience on that easement.
He has caused us some inconvenience on the easement. Yes, we were locked out for 3 weeks last summer. My husband's a farmer, and during July is not the time to lock someone out of their property. He ripped out a quarter-mile's worth of fencing. He took away our address. He stopped our mail delivery. He has caused us some problems. And that is why we had the lawsuit. We had Stewart Title Insurance defend the easement. And it's been a really bad year out there.
So
But it is valid.
okay, so I think that's been established, and I don't know that getting into the details is our responsibility. We're here to hear just the rezone part of that, and so I think we probably need to get back on track on where we're at on the rezone.
Thank you. And I would, just because I saw some head shaking and just that it is an easement to our, we're not fighting this in court. I just want to make sure we're clear on what we're here on.
So in the easement, it addresses the easement as a driveway. That's why I refer to it that way. That's the language used within the easement. In order to get a driveway permit from Elbert County, that permit goes from the road, which enters the county road system to your residence. So my permit has to go all the way from 7042 to the residence. So that's why I call it a driveway permit, and that's why it's there.
But do you impair access to her property?
There was 3 weeks that her gate was locked. It was right after we got told the easement was invalid, and our attorneys told us that there was a liability issue if we continued to allow them to cross our property without a valid easement. We reached out to them and we told them if they needed access to their property to call us, and we would gladly escort them there. After those 3 weeks, we talked with our attorney, and we decided that it was okay to allow them to continue to access. We took the lock off the gate, and as far as stopping people on the easement, I have no interest in doing that. I've never done that. I have had several of their guests stop at our house, and maybe they thought that that was the Hopper's place or whatever, but I've never gone out there and stopped somebody. The only time that I've gone out there, my wife went out there one time when they were getting work done on the easement area, or getting a bid for work done on the easement area, to listen to what the work was to be done, because it's our property. They're the dominant estate on it, they have rights to it, but it's still our property, and there are requirements for us to stop, unauthorized construction on that. And then there is a gate at the end of that easement area where the easement area meets the right-of-way. Colorado state law is that we're allowed to perimeter fence our property as long as they have access to it, and they do. They have, before there was a automatic gate opener there that I installed and gave them codes for, I paid for. That since has been removed, so now it's just a chain on the normal latch thing. There's no lock or anything on it, so they have full access to their property, and we're not trying to stop that.
Thank you. I mean, it truly is a matter that I understand is of probably more than an annoyance to folks in the room, but truly a civil matter outside of our jurisdiction. So I too am a little bothered by that's kind of an open-ended condition. It seems like the access exists, the easement exists to leave a potential revocation of zoning based on an easement. I mean, Colorado doesn't allow properties to be landlocked, so even if something were to occur with this easement, another would have to be provided in order to not landlock the Hopper's property. So I honestly think that condition should be removed. Otherwise, we're trying to police something that's way outside of our jurisdiction, and truly for a rezone, all we're doing is granting the allowable uses for this piece of property, not actually even defining what's on the property or platting what's on the property, nor is this the subdivision piece.
I would agree, and just add on to that, within our packet, we had the signed a mediation from both parties, so it obviously has established that there is a right-of-way there. So this just seems to be redundant to me. We've already have the documentation legally binding, signed by both parties, that there is a right-of-way, and any dispute they have amongst that right-of-way, it exists, that's their dispute. It's not our job to get in the middle of that.
Especially at this point where obviously the home exists.
Yeah, and I understand that sometimes neighbors have a disagreement over different things that they utilize together or adjacent to. This one, though, the roadway to the house already exists. It's already been utilized. And whatever that 3-week problem is, if I'm listening carefully enough, that has been recognized and working towards a resolution, or it has been resolved, I'm not sure. Mr. Chairman, I move we approve Gerald rezone RZ 239401 with the conditions of approval and if through 1, 2, 3, yes. 4 being removed.
Second.
Excuse me, a motion and a second to approve the application with the conditions 1 through 3 as presented by staff and 4 removed. All in favor, please say aye.
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 Aye. Motion carries. I would accept a motion to close public hearing on this item.
Mr. Chairman, I move we close the hearing on Gerald rezone RZ 239401.
Second.
A motion and a second to close public hearing on this item. All in favor, please say aye.
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 Motion carries. I'm going to call about a 5-minute recess, comfort break. Thank you. All righty, it's 1:49. We'll come out of recess. If you can just let the record show that all three commissioners have returned and we have a quorum. We will move on to our next item, which was the Ridgewood Estates rezone. Same general process. Staff will present the application. We'll ask for additional input from the applicant, take public comment, and then make a decision. For any time throughout there, we may have questions for applicant or staff. So with that, I would accept a motion to open the rezone hearing for Ridgewood Estates.
Mr. Chair, I'd like to move we open a public hearing for Ridgewood Estates, case number RZ-2023-1574.
Second.
We have a motion and a second to open the rezone for Ridgewood Estates. All in favor, please say aye.
Aye.
Aye. Motion carries. We're in public hearing. Mark, the floor is yours.
Thank you, Mr. Chair. Commissioners, Mark Denrader, Director of Community and Economic Development. We will present to you the Ridgewood Estates rezone, case number RZ-2023-1574. The request is a rezone from agricultural to residential 1 zoning. The size of the property is 421.35 acres. The address is at 1574 and 988 State Highway 86 in Elizabeth. Some more details here. We have Jim Marshall and Kirby Ross as the applicant owners, and then the applicant rep is the PCS group. And again, this property is on south of State Highway 86, just west of the town of Elizabeth. Pre-application meeting for this application took place on November 2nd of last year. Community meeting followed shortly thereafter, November 8 of 2023. A concept brief was required for this on November 13 of 2023, and then a formal application was submitted on January 4 of this year. The Planning Commission heard this case earlier this month on June 4th. That was a 6-0 vote recommending approval to the Board of County Commissioners. We did have a few different referral periods for this case, and all public noticing was done as required per the regulations. Here's a location map. You can see the blue star there indicating where this property is located, the cluster of development and the shaded area there in the darker light to dark gray. That's the town of Elizabeth, and you can see this is west of the town of Elizabeth along State Highway 86. Here's the zoning map, and you can see the two different parcels there that are combined for this application. The surrounding zoning, if you look to the north, we've got agricultural, residential planned unit development. To the south, residential PUD, and to the east as well, and to the west, agricultural zoning. Here's an aerial map. You can see again, the topography. You can see some of the trees that extend through the property, and some of the contours, and you can see the development of homes to the south in this image. And State Highway 86 is the red line on the map right at the top. Here is the rezoning exhibit. This project will have 186 lots with lot sizes that are going to be ranging between 1 to 3+ acres. There will be approximately 127 acres of open space and pedestrian corridors on the property. Ridgewood Estates will be built in several phases, based on how conditions dictate. The developer does plan to begin phase 1 and 2 with the smaller 1-acre lots that abut Highway 86 and the primary entrance along Legacy Ridge Street, with subsequent build-out would be expanding south with the larger lots in phases 3 and 4. The project will support its own centralized water and sewer system. The property is currently undeveloped, but you can see here in the exhibit map, this is a approximation at this juncture in the rezone phase of what this could look like, and the plans for the platting process naturally will occur later. Referral responses, here's a list of the various agencies that we send the application materials out to get comments. These are a few of the referral entities with no responses. The applicant did resolve any outstanding issues as it pertains to the referral process. And with all zoning applications of this nature, we go back to the regulations, Article 3C4, and we've got a criteria, a list A through F that you all will need to consider as we did as staff. And the first one is A, whether the proposed rezoning conforms to and is generally consistent with the goals of the Elbert County Comprehensive Plan. And we do believe it is consistent with the goals of the comp plan, the residential development goals of having adequate access and infrastructure, a general environment goal of minimizing impacts to open space, actually dedicating open space within the development. So that's a sound practice here. And if you go to B, as in boy, whether the proposed rezoning is compatible with surrounding land uses. Yes, the zoning, if you look at the surrounding property, there's agricultural land, there's also single-family residential communities, so there is a fit there. Moving further along in the review criteria, C, whether the proposed rezoning would adversely impact the provision of public services. There's no unforeseen issues with road access or availability of public services as was evaluated and expressed by the responding referral agencies related to this. Look at D, whether the proposed rezoning would adversely impact the environment. Environmental topics were also reviewed with referral agencies, and there was nothing identified in terms of issues. E, whether the proposed rezoning would create unreasonable traffic congestion or burden the existing road system without improvements. This is a rezone, as you know, so no impacts to roads at this time, but traffic impact analysis was submitted and reviewed by referral agencies and departments, and it was determined to be sufficient at this time for this stage of the application process. And F, whether the proposed rezoning will not otherwise be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County, and staff believes a rezoning of this nature will not be detrimental. That wraps up the review criteria. Then we go into findings. Staff does recommend that the Board of County Commissioners find these items here. The proposed rezoning is in general conformance with the Elbert County Comprehensive Plan. The proposed rezoning meets all the criteria for approval in the Elbert County zoning regulations. The proposal is compatible with existing and allowable land uses in the surrounding area, and the proposed rezoning will not result in significant impact to the health, safety, and welfare of the residents and landowners in the surrounding area. We arrive at a recommendation for you all. Elbert County Planning staff does suggest that the Board of County Commissioners approve Ridgewood rezone. It's case number RZ 2023-102 1574. And we have the following conditions. These are very standard in nature. The applicant will be required to remove the public hearing sign within 7 days of a decision of the BOCC. 2, the rezone exhibit will not become effective until all fees are paid, conditions of approval are met, and the rezone exhibit is recorded. And 3, recordation of all applicable documentation to occur within 180 days of the Board of County Commissioners' approval. That concludes our staff presentation, and we welcome any questions. Thank you.
All right. Any questions for staff? Okay. No, with that, I would invite the applicant or rep to present.
Pardon me, I'm just going to plug in a presentation for the applicant. So, one moment, please.
While he's doing that, I just want to thank you all for your time today in reviewing this application for us. I want to thank staff. They've been fantastic to work with and shepherd us through this process, so big shout out for them. I'm John Prestwich with PCS Group, 200 Calumet Street, Denver, Colorado, 80223. And we've been doing the land planning, ultimately landscape architecture for this new community. We can probably just go right to the second sheet. I'm not going to take a lot of time. You know, I always want to point out that it really does take a team to establish a community or an application like this, and so I always want to have a slide there that just kind of recognizes all the folks that have been integral in putting this application together. Obviously, as we get into the more detailed design efforts, there'll be even more folks that are helping us work through this whole process. I think everyone's pretty familiar with the site. This map just kind of tries to highlight it a little bit more clearly. Highway 86, Legacy Ridge Street, and of course the existing community to the south. We can just skip to the next one. This is really the heart of it for me. You know, we are just at the zoning stage, but as part of the requirements for zoning, we are obligated to provide you all with a concept plan of how we think the community will ultimately develop. And so for us, we really looked at a few big things that I wanted to point out. Number one, there's an existing large stand of ponderosa, primarily ponderosa pines on the property, and that is being preserved. You know, it's awfully tempting to kind of try and tuck homes in there. It's very valuable, but if we can preserve it for the overall community, we feel like that's a really big benefit. We are proposing a neighborhood park right at the edge of the Ponderosa Preserve area. And then the other kind of major feature that is running through, I don't really have a pointer, but there's you can see the homes all backing up. That's a drainage running through the property. So the really two major natural features of the property are being preserved through this planning effort. Additionally, the perimeter of the property is where we're adjacent to existing home sites, and those home sites that we're proposing are approximately 3 acres in size. So trying to be a good neighbor and buffer those folks, and then obviously do the normal things, providing 2 points of access and loop roads and some trail corridors and connections and things of that nature. Again, 186 home sites is what's depicted on this map. We have worked with staff and with referral agencies on some road connections and providing access to our neighbors in that out parcel, where I've of course put the label that says 186 home sites and 127 acres of open space. So, you know, again, I think the next slide is really just me wrapping up and basically kind of saying, you know, again, this application is just for the straight rezone at this point. You know, again, as required, we've shown you the concept plan. Obviously, this proposal has been through a very thorough review with both staff and outside referral agencies. And then, obviously, this is just the first step in the entitlement process. We believe the proposal, and staff believes the proposal is in compliance with the comprehensive plan. And obviously, Planning Commission also recommended approval unanimously. And with that, I'm happy to take any questions, and we've got some other folks here that if I stumble, they can help me.
Okay, thank you. Any questions?
Just looking at the map there, give me an idea what the average lot size will be.
It's a great question. So there's, oh, can you zoom in on that chart? I wonder if it shows it. We may have to do some, well, yeah, we range from 1 to 3 acres, but there's more 1 acre lots than 3 acres. So I would, if I had to guess, I'd say 1.5 acres, give it, you know, in that ballpark. And they're minimum 1 acre. I mean, you can see a lot of them where they're going around the corners and stuff are larger than 1 acre. And some of the ones that are, we're saying 3 acres, I think they get, there's one that gets pretty close to 5. So, I mean, it is a bit of a range at this point. Math was pretty good, right at about 1.5 acres.
Nothing more exciting than doing public math. Did have a, I guess, assuming we approve the zoning, when do you anticipate preliminary plat coming forward?
Well, Jim has released the engineers to be getting more detailed topo and starting the more detailed drainage studies to size the ponds and all of that kind of stuff. So not that he's kicked us off fully, but he has initiated getting all of the more detailed base information. So I would anticipate it's going to take probably 4 months to get an application together.
Okay, just kind of had caught my eye that CDOT didn't respond to the referral, and I know there's 2 excesses, additional excesses shown.
Correct.
Potentially, and whether that's just because it was a rezone and they're waiting for platting before they respond. That would be, yeah, okay.
Jim Marshall, 4091 East Chestnut Court, Greenwood Village. This project has been reviewed by CDOT many times. Also, the Colorado Department of Health and the Colorado Division of Water Resources, they've all seen this project, only it was 635 lots with a bunch of commercial. So everybody's seen this, and it went through fairly quickly on a lot of the referral agencies because when you go from 635 with a bunch of commercial down to 186 with no commercial, it was kind of like, okay, it worked before, it probably works now.
Thank you for that. That gives a little context. So.
And actually, it's probably about our 5th time through the process. So
All right.
I was wondering if we could give a brief synopsis of how the community meeting went with this, since it has been before the public so many times, how
Sure.
the meeting was for this one.
Yeah, I mean, I think it's fair to say that the folks that showed up were primarily in Wild Point, and they were pretty darn happy to see this design versus the previous ones. I mean, we did try to work with them in the past and provided some buffers and trails and some extra landscape, et cetera, that we tried to make them comfortable with. But in general, I mean, you know, they're going from 5 acre lots to 3 acre lots, and then to 1 acre lots, which seems like a very nice logical transition. And I felt like they were pretty darn happy.
I guess with that,
Where's the central water and sewer system going to be headquartered?
Well, I don't know if you want to talk about
yeah, we still have to work through the details on exact locations. We have a pretty good idea where the water well site's going to be. The low point in the drainage area is probably going to end up being where the wastewater will be for obvious reasons. But we've got a general idea. It'll be somewhere close to in the open space areas, close to the drainage area. And we'll work through all that detail as we move forward.
that's all we have here. So open for public comment at this point, if there is any. And seeing none, we'll close public comment. All right. And is there anything else from staff on this one? I don't believe so.
Mr. Chair, we have nothing else to present. Thank you.
Okay. And I will not make you come up, but the conditions of approval are satisfactory. We have a thumbs up. from the applicant rep, I would accept a motion.
Just a quick comment for those that are listening online and the public. This is just step one. It's just a rezone. It's come before us. We'll see it in many different iterations here coming forward, different hearings. But this is just strictly on the rezone. So, Mr. Chair, I move that we approve Ridgewood Estates rezone RZ 2023-1574 with the conditions of approval as listed.
Second.
Okay, we have a motion and a second to approve the Ridgewood Estates rezone 2023-1574 with the conditions of approval as presented. All in favor, please say aye.
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 Aye. Motion carries. I would accept a motion to close public hearing on this item.
Mr. Chair, I move we close the public hearing on Ridgewood Estates rezone RZ 2023-1574.
Second.
Okay, a motion and a second to close public hearing on this item. All in favor, please say aye.
Aye.
Aye. Motion carries. We're out of public hearing. Congratulations. Our next item is not public hearing, just a quick vote to assign a hearing date for Spring Valley Metro Districts 5 and 7. Do we have a date selected for that, Mark?
Yes, Mr. Chair. As you are aware, that this case was heard by the Planning Commission on June 18th of this month, and next it'll go to the Board of County Commissioners, and the date that has been requested is Wednesday, July 24th, 2024, for the Spring Valley Ranch Metro Districts 5 and 7.
I'd just like to make a quick comment. I'm out of town that day, so if is there an earlier meeting, Mark, that we could get on or not?
It is, I believe, noticing it may already be connected to this date.
Okay.
So,
I mean, I can
that is up to
participate
you.
online.
Or we could.
It's not that big a deal, I don't think. There is a pretty tedious presentation that you're going to endure, but
We'd like you to be here for that.
as long as I can participate virtually,
Okay.
it'll work for
Yeah, and if something does come up and you're not able to participate remotely, we could open and continue to another date. So, okay, so with that, I would accept a motion to set a hearing date for Spring Valley Metro Districts 5 and 7 on July 24th, 2024 at 1 p.m. at this location.
So moved.
Second.
All right, we have a motion and a second to set the hearing date for Spring Valley Metro Districts 5 and 7 on July 24th, 2024 at this location at 1 p.m. All in favor, please say aye.
Aye.
Aye. Motion carries. All righty, so that's set. And then next item we have is also a public hearing, but it's for some minor regulatory updates. So I will turn that over to you, Mark.
Thank you, Mr. Chair, Commissioners.
But first, I'll open the hearing. So I take it back.
Mr. Chair, I'd like to make a motion. We open a public hearing on the consideration of some minor regulation updates.
Second.
Motion and a second to open public hearing for regulation updates. All in favor, please say aye.
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 Aye. Motion carries. We're in public hearing. Back to you again, Mark.
Thank you, Mr. Chair, Commissioners. Mark Daddenreader. As you are aware, this came before you initially on June 12th of this month, and it was continued. There were a couple items that you all requested to consider. One had to do with mail notifications, noticing sent via certified or registered mail. The other one pertained to road acceptance and adding that neighborhoods or HOAs take responsibility for all signage. We, as staff, initially thought that these changes might be substantive enough to go back to Planning Commission. We looked at it further, consulted with county legal and so forth, and that is not the case. So we kindly request a continuance for Wednesday, July 10th or July 24th to work on these items and get them back in front of you in a packet prior to a public hearing, and we can move forward.
Do you have a preference on which one?
More time is better, probably.
I was looking at the calendar, and sometimes you know how it goes, the last meeting of the month, sometimes you get a little extra break until the first BOCC meeting. So with the holiday and so forth, the 24th would be great if possible. Thank you for your consideration.
Reasonable? I would accept a motion to continue.
Mr. Chair, I'd like to make a motion to continue the consideration of these minor regulation updates to time date certain, July 24th, 2024, 1 p.m. in this location.
Second.
Okay, we have a motion and a second to continue the consideration of the regulation updates to July 24th at this location at 1 p.m. All in favor, please say aye.
Aye.
Aye. Motion carries. I'd accept a motion to close the public hearing on this item at this time.
Mr. Chair, I move that we close the public hearing at this time on the minor regulation updates.
Second.
A motion and a second to close public hearing on the minor regulation updates. All in favor, please say aye.
Aye.
Aye. Motion carries. Do we have any other land use business, Mark?
There's nothing else to come before the board. Thank you.
All righty. We have no other business today, so I would accept a motion to adjourn.
Mr. Chairman, I move we adjourn.
Second.
A motion and a second to adjourn. All in favor, please say aye.
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 Aye. It's 2:16 and we are adjourned. Thank you.